And our speaker was just fantastic. And he really did set the keynote for the rest of the week when he talked about backward glancing to the forward marching. I know he said "and," but I like "to the forward marching," because we have clearly seen this week so far what happened in Brown versus Board of Education, or Davis versus County School Board of Prince Edward. We've talked to some of the plaintiffs, or we've heard from some of the plaintiffs involved therein. We've heard about massive resistance of the Commonwealth of Virginia, and we heard about the impact that massive resistance had on our county as a result of closing of public schools. Tonight, I had hoped to have someone come in and talk to us about Griffin versus County School Board. But it appears as if you're stuck with me. You call, my dear? I thought I might just highlight the Supreme Court decision in Griffin, because I didn't believe many of us had actually read it or even knew about it or had any understandings of how it got to be what it was. I like telling people that the Griffin versus County School Board of Prince Edward was decided May 25th, 1964. And the following morning, the banner headline in the Richmond Times-Dispatch, which was the statewide newspaper at that time, read, "Who the hell is Keith Griffin?" Because Griffin had said some things that impact the entire state of Virginia. And the Times-Dispatch editor or publisher at that time was James Kilpatrick. And he had been one of the leading forces in massive resistance. But before I read this to you, or at you, or with you, I want to make sure we are clear, because there's going to be some terminology in here. Our federal judicial system is structured with district courts, and above the district courts are Court of Appeals, and above the Court of Appeals would be the United States Supreme Court. Most of our cases that we're going to be hearing about would have been in the Eastern District of Virginia, United States District Court for the Eastern District in Richmond, and all of the appellate work would have been to the Fourth Circuit Court of Appeals, which sits in Richmond. And the Fourth Circuit Court of Appeals covers the states of Maryland, West Virginia, North Carolina, South Carolina, and Virginia. And the Eastern District Court of Virginia would start at Alexandria and come down 95 and swing over to include Powhatan, Cumberland, Prince Edward, and on down to Lunenburg. The rest of the state would have been in the Western District. So as you hear these things, I just wanted you to make sure that you had an understanding of what was being done. Now, even beforehand, as Dr. Ferguson said today, the resistance in the Commonwealth wasn't physical lynching, it was legal lynching. Because between the court's decision in Second Brown, the Davis versus County Board of Schools was appealed from the Eastern District of Virginia to the Supreme Court because there were some other jurisdictions involved on this issue. It was initially heard in like 1953. But before a decision could be made, Chief Justice Vinson died. Fortunately, the work of the Lord. And when Chief Justice Vinson died, Dwight David Eisenhower appointed who he thought was a reasonable man by the name of Earl Warren, former governor of California. And as a result of a new Chief Justice, the case had to be re-argued. It was re-argued in the latter part of 53, and that May 17th, 1954, these 9 white men in black robes sat at the Supreme Court, and Chief Justice Warren read the decision. Yeah? Read the decision, and when you now try to print that decision on your printer, it's going to encompass some 40 pages, and the Chief Justice read it. And that was to say a separate but equal was unconstitutional. And the court said, we're going to have to come back for the establishment of a remedy. So in 55, the court came up with the remedy of what? No? With all deliberate speed. You got to integrate with all deliberate speed. Okay? That's where that phrase came from, right from the court's opinion. But between 55, 56, all the way up to 63, there were some 8 cases filed in Prince Edward to try to get Prince Edward to follow the rules. Okay? Prince Edward refused. And as we read this opinion, you're going to hear the history from the Supreme Court of the refusal of Prince Edward to do what it was supposed to do. As we read this, we're going to hear all of these cases of Eva Allen versus County School Board of Prince Edward County. Because Mr. Hal Allen, Eva's father, believed that the county was wrong and he was going to do everything he could to make sure this was righted. And he and his family filed a slew of cases before we even got to Coquise. You with me? In fact, well, you're going to hear it as I read it. And it's not that bad. You all might think that we lawyers talk in language unknown to most of you, but it's really good King's English. Coquise J. Griffin et al., because all of her sisters and brothers were listed, but the lead name was Coquise, versus County School Board of Prince Edward, argued March 30th, 1964, decided May 25th, 1964. Now, that is pretty expedient, isn't it? Argued before the court on March. By May, the court had made a decision. And as you hear it, you can see why the court was so mad, so upset, and was so determined this time to put an end to it. Robert L. Carter, New York, for the petitioners, Archibald Cox for the United States, J. Sigurd Gravett, Blackstone, Virginia, representing the county, and the decision was written by one Justice Hugo Black. Anybody remember Hugo Black? What do you remember about Hugo Black? He was on the Supreme Court, but what else about Hugo Black?
He started out with the KKK.
Absolutely, a KKK'sman, Hugo J. Black. But after his appointment to the court, he became a new man. Just as an aside, a lot of us thought that with the once Clarence Thomas was appointed, he would become a new man. But clearly, he ain't no Hugo Black. Listen to this. This litigation began in 1951 when a group of Negro school children living in Prince Edward County, Virginia, filed a complaint in the United States District Court for the Eastern District of Virginia, alleging that they had been denied admission to public schools attended by white children, and charging that Virginia laws requiring such school segregation denied the complainants the equal protection of the laws in violation of the 14th Amendment. On May 17, 1954, 10 years ago, we held that the Virginia segregation laws did deny equal protection in Brown versus Board of Education. After re-argument on the nature of relief, we remanded this case, along with others heard with it, to the district courts to enter such orders as necessary and proper to admit complainants to public schools on a racially non-discriminatory basis with all deliberate speed. Now, in Brown, there were 5 jurisdictions: Prince Edward, Clarendon, South Carolina, Topeka, Kansas, Washington, D.C., and Wilmington, Delaware. And what this line there is saying, that the Supreme Court in 55 sent the cases back to the district courts to come up with the necessary orders to make sure these school divisions did what they were supposed to do as found in Brown. With me? Efforts to desegregate Prince Edward County School met with resistance. In 1956, Section 141 of the Virginia Constitution was amended to authorize the General Assembly and local governing bodies to appropriate funds to assist students to go to public or non-sectarian private schools, in addition to those owned by the state or by the locality. Now, this says 1956. So within a year of 55, as Dr. Ferguson said at lunch, the state constitution had been amended so that tuition grants could be paid, and not only tuition grants paid, but they could be paid for private non-sectarian schools. The General Assembly met in special session and enacted legislation to close any public schools where white and colored children were enrolled together. to cut off state funds to such schools, to pay tuition grants to children in non-sectarian private schools, and to extend state retirement benefits to teachers in newly created private schools. Huh? Now, this is the Supreme Court spelling out all of the vicious things the Commonwealth had done. And today we even heard from Mrs. Franklin, who said she taught 1 year in the free schools, and the Commonwealth would not recognize that 1 year in her retirement package. But in '56, they had already passed a constitutional amendment saying that for white teachers teaching in these schools, they were going to get retirement. So I can fully well imagine that all of the white teachers who were teaching at Farmville High, who then went over to the private academy, got credit for all of the years that they taught at the academy under the Virginia retirement system. Huh? The legislation closing mixed schools and cutting off state funds were later invalidated by the Supreme Court of Appeals of Virginia, which held that these laws violated the Virginia Constitution. This decision was made in 1959. Okay? In April 1959, the General Assembly abandoned massive resistance to desegregation and turned instead to what was called a freedom of choice programs. The Assembly repealed the rest of the '56 legislation as well as tuition grant law of January '59 and enacted a new tuition grant program. At the same time, the Assembly repealed Virginia's compulsory attendance laws and instead made school attendance a matter of local option. In June 1959, the United States Court of Appeals for the Fourth Circuit directed the Federal District Court for the Eastern District of Virginia to enjoin discriminatory practices in Prince Edward County schools. 2, to require the county school board to take immediate steps toward admitting students without regard to race and to the white high school to begin the September 1959 school term. And 3, to require the board to make plans for admissions to elementary schools without regard to race. This was in June of '59 when the Fourth Circuit Court of Appeals made this ruling. They made that ruling in the case of Eva Allen versus County School Board of Prince Edward, decided in the Fourth Circuit Court of Appeal in 1959. Having as early as '56 resolved that they would not operate public schools wherein white and colored children are taught together, the supervisors of Prince Edward refused to levy school tax for the '59-60 school year, explaining that they were confronted with a court decree which requires the admission of white and colored children to all the schools of the county without regard to race or color. As a result, the county's public schools did not reopen in the fall of '59 and have remained closed ever since. Although the public schools of every other county in Virginia have continued to operate under laws governing the state public school system and to draw funds provided by the state for that purpose. A private group the Prince Edward Foundation, was formed to operate private schools for white children in Prince Edward County, having built its own plant, has been in operation ever since the closing of the public schools. An offer to set up private schools for colored children in the county was rejected. The Negroes of Prince Edward preferring to continue the legal battle for desegregated public schools, and colored children were without formal education from 1959 to 1963, when federal, state, and county authorities cooperated to have classes conducted for Negroes and whites in school buildings owned by the county. During the 1959-1960 school year, the foundation schools for whites were supported entirely by private contributions. But in 1960, the General Assembly adopted a new tuition grant program, making every child, regardless of race, eligible for a tuition grant of $125 or $150 to attend a non-sectarian private school or a public school outside his locality. The Prince Edward Board of Supervisors in 1960 then passed an ordinance providing tuition grants of $100 so that each child attending the Prince Edward School Foundation received a total of $225 if in elementary school or $250 if in high school. In the 1960-61 session, the major source of financial support for the foundation was in the indirect form of these state and county tuition grants paid to children attending foundation schools. At the same time, the County Board of Supervisors passed an ordinance allowing property tax credits up to 25% for contributions to any non-profit, non-sectarian private school in the county. Now that's not legalese, is it? That's pretty good King's English that all of us can understand, showing what these people were actually doing and had been doing. And the court now has taken statements from the petitioner's briefs to come with these facts to show what was going on. In 1961, petitioners here filed a supplemental complaint, adding new parties and seeking to enjoin the respondents from refusing to operate an efficient system of public free schools in Prince Edward County, and to enjoin payment of public funds to help support private schools, which excluded students on account of race. The district court, finding that the end result of every action taken by that body was designed to preserve segregation of the races in the schools of Prince Edward County, enjoined the county from paying tuition grants or giving credits so long as public schools remain closed. Another Eva Allen versus County School Board of Prince Edward County, decided 1961. At that time, the district court did not pass on whether public schools of the county could be closed, but abstained from making that decision pending a determination by the Virginia courts of whether the Constitution and laws of the Commonwealth required public schools to be kept open. Later, however, without waiting for the Virginia courts to decide the question, the United States District Court for the Eastern District of Virginia held that the public schools of Prince Edward County may not be closed to avoid the effect of the law of the land as interpreted by the Supreme Court, while the Commonwealth of Virginia permits other public schools to remain open at the expense of taxpayers. Another, Eva Allen versus County School Board of Prince Edward, decided 1962. Now, listen to that closely. This is 62. The U.S. District Court for the Eastern District of Virginia has ruled in 62 that if public schools don't operate in Prince Edward, they can't operate anywhere in the Commonwealth. That was in 62. Okay? But right after that decision was made, the county school board appealed it to the Fourth Circuit Court of Appeals, and the Fourth Circuit Court of Appeals reversed the district court, telling the district court, you should have waited to see what the Virginia Court of Appeals was going to say about the constitutionality of this. This is what the court said. Soon thereafter, a declaratory judgment suit was brought by the County Board of Supervisors and the County School Board in the Virginia Circuit Court. Having done this, these parties asked the Federal District Court to abstain from further proceedings until the suit in the state courts had run its course. But the district court declined. After the district court declined to hold its decision in abeyance until they could get a decision from the Virginia Supreme Court, the defendants appealed to the Fourth Circuit Court. And the Fourth Circuit Court of Appeals in 63 said the district court was wrong. Listen to this. The plaintiffs appealed to the Supreme Court. The Supreme Court granted certiorari, granted an appeal. In most courts, in the federal courts, you don't have a right to an appeal per se. You got to ask the Supreme Court to give you an appeal, and you have to show in your request to the court that the lower court did something wrong. Okay? The Supreme Court agreed to take the case and went on to say, in view of the long delay in the case since our decision in Brown and the importance of the questions presented, we granted cert and put the case down for argument on March 30th, 1964 on the merits. For reasons to be stated, we agree with the district court that under the circumstances here, closing the Prince Edward County schools while public schools in all other counties of Virginia were being maintained, denied the petitioners and the class of Negro students they represent the equal protection of the laws guaranteed by the 14th Amendment. Now, keep in mind now, this case started when? 59. We're now up to 63. And it wasn't until 64 that the decision was actually made. The case clearly was one of those that the court had decided they were tired of Prince Edward dragging its feet, and that there was nothing left for us to do but to force them. And what was the force?
Prince Edward had to be closed, and all of them had to be closed.
That's right. And once that decision came down, who the hell is Keith Griffin? Because the decision had the impact of closing public schools and everywhere. And as a result, we know that the powers to be told Prince Edward, hey, we ain't closing our schools, you're going to open yours. And I like to say that Griffin didn't force public schools to reopen in Prince Edward. Griffin saved public education. And that's a vast difference than just saying, I forced you to reopen, because by that time, lots of the school divisions had been operating in some form of desegregated situations. And for Prince Edward not to have operated anything clearly wasn't going to fly well with everybody else. This case again, as you heard, the Allens, Hal Allen and his children, were unbelievable litigants in this process. Mr. Allen was a spirited man, wasn't he even? And once he got his beliefs in place, it was hard to get him deterred from that belief. And it's fortunate for us that he was like that, because his efforts in having named plaintiffs made it easier for us to eventually get to Griffin, because Allen had set in place what Griffin was finally able to accomplish. It's amazing to me that as a Prince Edwardian, growing up here, having been in the 8th grade when public schools closed, to have an opportunity in 1973 to go and work with Oliver Hill and Sam Tucker in their law office. And when I got there, we were still handling school desegregation cases. We were handling, I assisted with a issue at Hanley, is it Hanley or Henley? Henley High School in Winchester. Where's my minute? Huh? Handy High School in Winchester. It's a very interesting situation, because it's one of the few endowed public high schools in the Commonwealth, if not the only one. And there was an issue as to whether or not they were going to allow, they'd already allowed black students in, but as to how black students were being disciplined different from white students. And because their school desegregation case had not been removed from the docket of the Western District of the United States District Court for the Western Division, we were able to have a hearing in Roanoke before a federal district court judge, and the judge clearly took the administration through the ringers for the way they had been treating those black students. But it just goes to show the importance of lawyers being in contact with their communities, and the communities having enough faith and confidence in their lawyers to call on them in their needs. It's an amazing decision and an amazing litigation history for us. I just ran off, I printed just some of the Allen and Griffin cases, and you can see that's a pretty good stack of paper. And I did not print Brown, because if I had printed Brown, I would have had to go to Key Office Supply and buy some ink. But it is an unbelievable history of what types of things we here in Prince Edward went through in order to be where we are today. I believe I have exhausted everything that I wanted to tell you about Griffin, and would give way for any questions or discussions that we might have. We don't take questions from lawyers. Yes, ma'am.
Mr. G, your concluding comment is what my question is.
Oh.
Where is Prince Edward County today?
With regards to what?
Sort of overall.
Overall. Now, I think we are doing very well. We have a black elected sheriff who is serving his second term, who succeeded a black elected sheriff who served 12 years before the second one was elected. And you know, in the South, for a black man to be in charge of the police is amazing, isn't it? We had a black elected clerk of the circuit court who served about 10 years until her retirement. We now have a black Commonwealth attorney who is seeking her second election for that job. We have, I believe, 4 blacks out of the 8 members on the Board of Supervisors. I believe we have 3 blacks out of the 8 members on the Prince Edward County School Board. We have a black superintendent of schools. We have a county government that seems to be willing to appropriate funds for public schools, might not be appropriating funds at the rate that we are capable of paying. And we have a black vice mayor of the town of Farmville. We have 2 blacks who served on Farmville elected town council out of 7. And we have in every constitutional office in the courthouse a 1 or 2 black employees. In fact, we have a black employee in the Commissioner of Revenue's office who is now seeking election as the Commissioner of Revenue. Stand up there, Ms. Goldman, so these folks can see. Now, I'm not, thank you, Ms. Goldman. I'm not saying that just because we have black elected officials that all is well, because all is not well. There is a lot more that could be done and a lot more that needs to be done. But you know, I always, well, I'm not always, but I said to lots of people now, especially in the adjoining counties, I said, can you believe that today in Prince Edward County, no white man holds a constitutional office position? That's mind-boggling, isn't it? No white man holds a constitutional office. 50 years ago, all of the constitutional offices were white men. Okay? And today, no white man holds a constitutional office. I told this to a guy over in Buckingham the other month, and his jaw dropped. You know, are you sure? Are you sure, G? Yeah. But I'm not saying that doesn't mean we still don't have a lot of work yet to do. But it does mean that we, I believe, are on the right path. Okay? And as we build on this path, you know, last night our speaker told us about how things go up and down, huh? And how sometimes things look good, then they would look bad. I think we are on this upswing, but we still have a long ways to go. I thought you were asking one question about my Yes, ma'am.
For those of us who are not from here, and we're very honored to be here today, would it be possible for all of those who are here tonight who are directly impacted by the closing to stand up so we can just honor and thank you for your service?
Do we have any other questions? Any other comments? Well, I thought you were taking up for Rick Turner.
Well, I'd like to.
Yes.
First of all, I really, again, I cannot overemphasize how appreciative we are for the presentations and the conference that you put on this weekend. And to just let you know, to answer her question, how far you've come and where are you now, you mentioned Hanley High School. I'm the legal redress officer for the Winchester branch.
Woo.
And yes, and one of the things that we are still fighting there is the disparity in discipline in the schools. And so for you to say that, you know, you have your elected officials, we have an elected mayor, a black mayor. However, the rest of the leadership has not come along. So Prince Edwards, I'm telling you, whatever you've done, keep doing it. We are very envious of what you are doing in the Winchester area. We're a lot larger than you are, but I'm telling you, we are years behind you as far as our race relations and our ability to govern justly. And to give you another example, our teachers, our school system, the city school system, if you can go through and find 5 black teachers, you've done well. Okay.
Yeah, but I think that's a problem everywhere.
Right.
Because we have that problem here also.
Okay.
It's hard because I guess Stiff, who serves on the school board, she would know whether or not there is a large pool of black teacher applicants that can be drawn on. And she's going to tell you that they have a huge problem even here, everywhere. And that's because we don't seem to be creating as many black teachers today as we did 20, 30 years ago. Yes, ma'am, Miss
Let
Jess.
me say,
Uh-oh. Don't stand up, though. Just go on and say it.
some of the teacher shortage, the lack of teachers, has to do with funding. I would employ all of us to become advocates for money. Put it simple. And let me give you a case in point as to why I say that. We're in Region 8.
Of the school breakdown.
Breakdown. Thank you. Virginia State stuff. A teacher can spend, I'll just say 30 years in the system and retire somewhere in the neighborhood between $50,000 and $55,000. 30 years. My daughter works in Baltimore, third-year teacher, makes that now. Anytime there is a teacher that's needed in Northern Virginia, for instance, that can pay more, where do you think that teacher is going to go? Absolutely. And you can't fault them. So the issue for most districts here in the state of Virginia, I know, is funding. Help us out.
Any other questions?
I would like
Dr.
Scott.
No. I was talking to Dr. Scott in the back. Yes, Scott. No, you go on, Dr. Scott. Don't let me.
No.